SJC-13595, Commonwealth versus Arickson, Cruz.
Good afternoon, and may it please the court. Cruz's conviction can't stand for the same reason the defendant and countermans couldn't. Oh, I'm sorry, I forgot to introduce myself. My name is Rachel Rose, arguing for defendant appellant Arickson.
Hey, can you, I remember from last time you spoke, could you slow down, okay? Because you're speaking through a mask and you're talking really fast.
This time I will get it right.
Okay.
Cruz's jury instructions only asked what a reasonable person might think of what he said, not whether he, the speaker, was at least consciously disregarding a substantial risk that his communication would be viewed as a serious threat of violence. The Supreme Court is clear that the Constitution doesn't allow punishment of speech that's only unintentionally or negligently threatening, even if it contains outwardly violent language. That's all that the Commonwealth proved this was, so it needs to be reversed. You can't substitute a per se rule for the determination of intent that the Constitution requires, or a lot of the angry rhetoric and even jokes that we see all the time becomes illegal and subject to prosecution as soon as they're communicated to a particular person or the listener thinks you're talking about someone in particular. That's an unbelievably draconian state of affairs, and it's completely inconsistent with the First Amendment.
Okay, so just to clarify, the missing element here, there was a four-part instruction, but we have one missing piece to that instruction, right, which is that the state must show the defendant consciously disregarded a substantial risk that his communication would be viewed as threatening violence, right?
Yes, that's right.
So if that had been in the instruction, that instruction would be fine, correct?
That would be fine.
The rest of the instruction, and he's going to stand up and argue that other parts of the instruction, particularly 1 and 2 maybe, that the defendant intended that his threat be conveyed to a particular person, and third, that the injury that was threatened if carried out would, it's 2 and 4, I think he's going to argue, make up for that. 4, that the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear that the defendant had both the intention and the ability to carry out the threat, right?
That's correct.
So tell me why he's wrong, okay?
Why he is wrong?
Why the Commonwealth is wrong, okay?
Well, what the government is asking for is basically that if you say any outwardly violent words, then that's an expression of an intent and anyone can reasonably take it that way. Yes, and that's true. Anytime someone says something that on its face is a violent threat, there's always somebody, even a reasonable person, who could take it that you're speaking seriously. But the Supreme Court is clear that that is not good enough to protect our freedoms under the First Amendment, that we have the right to make these sort of jokes, that we have the right to make this sort of angry rhetoric if we are only unintentionally or negligently saying something, unless we really know that that is how it's going to be received when we say it. That's something that the government can't punish.
Okay, but let's just get into the weeds here a little bit. So the defendant intended that his threat be conveyed to the victim, okay? And then the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear that the defendant had both the intent. So I see that there may be a missing piece here, but it's pretty close, right? You're intending the threat to that person, and the threat that you conveyed reasonably could have caused the person to made the threat under circumstances which reasonably could have caused the person who was conveyed to fear that the defendant had both the intention and the ability to carry out the threat, right?
Well, it's not that. I mean, it actually is quite different. It's the difference between, in plain terms, I can see how it could be taken that way, and anyone should have known that's how it would be received. And there's a lot of jokes, there's a lot of political rhetoric, there's a lot of discussions that go on to a particular person. We're not dealing with
jokes and political rhetoric. We're dealing with, if you touch my kids again, I can't remember, what's the end of it?
If you touch my kids again, I'll punch you in the face.
Okay, so there's not a lot of ambiguity there, right?
Yes, the question is whether it was intended to place her in fear of an illegal act or whether it was intended to tell her to leave my kids alone.
You're talking about the absence of a mens rea requirement of at least recklessness, and here the statute or the elements as instructed have the reasonable person objective standard, correct?
That's correct. And the Counterman decision has said, I mean, almost in exactly those words. The instruction.
Why is this statute vague? Why can't we just fix it?
Well, the statute isn't vague so much as it's facially overbroad.
Well, why can't we fix it?
You'd have to fix the statute itself.
We'd
Sticking the jury
have to
instruc-
give jury instructions that conform to the new SCOTUS case,
Well,
right?
see, what was done last time was in Commonwealth v. Shawley, Counterman says that the kludge of redefining threat that was used last time isn't good enough. They said if courts were at liberty to redefine what counts as a threat, this would achieve the same results as creating new categories of unprotected
But
speech.
wouldn't we say these jury instructions are flawed, the objective standards out, put in a recklessness standard?
If you revise the jury instructions, yeah, only prosecutions of true threats would reach conviction. But
Right.
that does nothing to solve the chilling effect problem. This is that the counterman in court is clear as why they made this ruling. So for a statute punishing only pure speech, on its face, 275 Section 2 covers a lot of ground that falls outside of any of the exceptions to the First Amendment. Only violent threats are true threats, but if you read the language of the statute, combined with the instructions that Cruz's jury received, that would have allowed for a conviction over a threat to vandalize a neighbor's offensive yard sign. You can prosecute for doing that, but you can't prosecute for saying it. Whether his text message was intended as a real threat or just angry hyperbole wasn't something that his jury was ever asked to decide, but it was the dividing line of illegality and the only thing at issue in the case.
Remind me, did the Supreme Court rewrite the statute in its case, or did it just redo the jury instructions?
I struck it down, I think. Yeah. But in any case, it's not a direct corollary of the statute in that case because
To
it's a
answer the
stalking
question,
statute.
if you know the answer, it would be nice to tell us.
He used to.
Because I see your point about chilling effect. When you don't know what the jury instructions are when you're threatening the victim.
Right, the
But
jury
I'm trying to
instructions-
figure out what the Supreme Court actually said.
Well, in terms of overturning, well, the Virginia statute can't really be compared to, that section of it can, but let's see.
That's important, because if they said, okay, if you narrow it through instructions or interpretation, that gets away, that they're comfortable with the chilling effect that you're not comfortable with.
No, they just vacated the judgment and remanded for, but the reason
They
that
did,
that.
you're
They did
speed
not overturn
talking.
the statute in that case.
I still can't hear you. What?
They did not overturn the statute. The reason, this is a very different statute, though. This statute is just a threat to commit any crime against persons or property. Even limiting that via jury instructions, there's a reason we look at statutes punishing pure speech with special care, and it's because most of the chilling effect of not being able to speak your mind is already achieved by the prospect of being hauled into court and run through a jury trial over something you said.
So, sorry, just to understand, is your argument that it is insufficient as a matter of law for this court to say no one can be prosecuted under our true threats statute unless they prove the element that the Supreme Court has required pursuant to the First Amendment that the Commonwealth has to prove, and that going forward, no one can be prosecuted under the statute unless this particular mens rea is proved? And you're saying that we would still have an ongoing First Amendment violation here in Massachusetts, even though this court had declared that our statute includes that specific intent?
That's correct. Under Counterman, that opinion no longer seems to hold. They decided several things in that were still up in the air at the time of.
Well,
Shawley.
Counterman was a federal U.S. Supreme Court decision reviewing a state court decision. So it's not surprising to me that they wouldn't rewrite a state law, which they have no power to do. All they had the power to do is to say what the First Amendment requires. But we have actually authority over what the content of Massachusetts law is. So I'm trying to understand what is the basis for your argument that this court cannot say that going forward, all prosecutions under the statute have to include a jury instruction with such and such mens rea going forward. And you're saying that the statute would still be overbroad and there'd still be a First Amendment problem?
Right. This court has the power to do that, but it shouldn't, simply because it does nothing to solve that problem that the Counterman, in particular, Sotomayor's concurrence, talks about so vividly.
So is that because people don't know what the content of our decisions are, and so?
Well, the jury is never told, the jury is not the one who is supposed to be deciding whether something is a true threat subject to prosecution under the Constitution. That by the time it reaches the jury, that's already supposed to have been decided. So they're not, the only question, well, what you're left with is prosecutorial discretion. Prosecutorial discretion here, It's not
I
sufficient.
thought your argument was really about the language of the statute being, providing a chilling effect to the public, regardless of whether we read into, as we must, a mens rea requirement under the First Amendment.
Well, yeah, I mean, the statute on its face bars any kind of threat to any person or property. That's enormously broad. A lot of the things that we might say might fall into that. And it would cause people to, what, as they say, steer wide of the danger zone. But I'd like to talk about dismissal for a moment.
You may want to keep answering that question before you.
I'm sorry, what?
Yeah, so I guess,
I
you
don't
know,
understand.
we've fixed statutes before because there have been, if a certain reading causes them to be unconstitutional, what is it about this statute that we can't save it by reading it consistent with counterment?
Well, you'd have to read in an intent requirement into the language of the statute
Which is,
itself.
you know, as I understand criminal law 101, there's mens rea and actus reus, and so the mens rea here is risk.
It is my alternate request that the jury instructions be changed. It's simply because the statute itself would not be. When what you're trying to punish is violent threats made with a knowing or reckless intent to place someone in fear. That shouldn't be terribly difficult to get something that's narrowly tailored enough to achieve the compelling state interest of protecting people from coercion through fear of violent attacks without leaving the general public worried that police are going to show up at their door if they say anything to anyone that's remotely interpretable as a threat. And Justice Sotomayor's concurrence goes on about this a lot, particularly in online. Returning to Cruz specifically, this is a text message. It's not an angry yell delivered right into someone's face, shaking a fist like in Shawley. It's not a message written in blood pushed under their door. If he can be prosecuted, a lot of people can. I swear to God, if you touch my kids one more time, I'll punch you in your face.
You're forgetting the prior bad act that was introduced into evidence of another text message. I wish you all die, bitch. I'm so hurt, etc., etc. F you. I hope you die, bitch.
And they were clear that that was not the single utterance of pure speech that he was being prosecuted for under a true threats exception.
No, but I mean, as far as a directed verdict goes, or a fact that he can be retried, I think you have an uphill battle, given that this isn't, given the direct threats to punch her in the face.
Well, the jury is free to disbelieve him when he says, I was just telling her to stay away from my kids, and she, I was angry, I didn't mean it, I didn't ever think she'd take it literally.
That's why we have trials. Of course they can disbelieve her.
Even if they agreed with him completely here, the jury instructions would have instructed them to convict.
Well,
And that's
I
the problem.
think what based on the SCOTUS case, and I think from the question, you can infer that we all think that there needs to be a mens rea requirement, and the jury instructions were flawed.
Going back to Justice Wentland's question about your argument, do you have an overbreadth argument that's distinct from the mens rea argument? Because I understand Mr. Counterman had raised these First Amendment issues before Counterman was even decided. And in fact, this was all briefed to the appeals court before Counterman was even decided. So is there, I don't mean we shouldn't lose the forest for the trees here. Obviously, Counterman is very significant and may need to be addressed. But is there an additional part of your constitutional argument as to why our statute or his prosecution violates the First Amendment that is a distinct problem aside from what we'll call the Counterman problem?
Yes, absolutely. And in fact, my brief to the appeals court echoed some of the arguments that Justice Sotomayor's concurrence makes. Not all of them. It particularly makes an argument that all threats are conditional in the give me your wallet or I'll shoot sense, but that shouldn't make it illegal that to warn someone that you'll use physical force against them if they don't leave you and your family alone. And that's where the unlawful part comes in, that it isn't a true threat, a serious expression of an intent to commit unlawful violence, because at least to the speaker, the conditional violence that they're threatening could be justified. If you touch my kids again, I'll punch you in the face. There are certainly circumstances under which if someone keeps touching your kids when you don't want them to, punching them is allowed.
I don't think so. If someone touches your child, I mean, if they touch them inappropriately, yes, but if they just touch them, you can punch them in the face? I just don't know if that's allowed.
I mean, this would be a different thing if you were sending this text to the kid's teacher, absolutely. But this is somebody who he never expects to encounter her again. It's hyperbole. Even with the facts considered in their best light, the Commonwealth knows that what he's trying to say to his ex-girlfriend is stop hugging my kids or else. It's not, I'm going to hurt you. The recklessness standard applies to every part of what makes something a true threat. This is going back to counterman again, but it is relevant because the speaker has to have known that anyone would think that what he's threatening is unlawful violence. And as you point out, Justice Kafker, there are situations where someone who's kidding someone who won't stop touching your kids, many people would support.
Would it include a situation where, because of the prior relationship, the kids just ran up to hug her?
No, he would. There's no argument that he would not have been justified in punching her after this encounter. There is none. But that's not what he threatened. That is not what he said he was going to do.
Okay.
Okay.
I see I'm out of time, so
Yes.
I'll rest on my brief. Thank you.
Thank you. Okay, Attorney Nadeau.
Thank you, Madam Chief Justice. May it please the court. Good afternoon. Stephen Nadeau on behalf of the Commonwealth. I acknowledge that I'm 88 Gauthier, wrote the brief in the case. I'm standing in for today. I hope I'm a suitable replacement.
You're a brave man.
Our position is that neither Cruz's conviction nor our threat statute have been invalidated by the Supreme Court's decision in
So
counter.
where do you read in the mens rea required by counterman in the jury instructions?
I think that comes twofold. There is an intentional communication
Intent to convey.
of an intent to inflict harm. So as opposed to the counterman problem where the mens rea was only as to the act of communication itself with no reference to what that communication contained, here the communication must contain an intent or an expression of an intention to inflict a criminal harm or to do criminal violence.
But it's the intent modifies convey. So wouldn't it be the circumstance where I tell a friend and the friend discloses a threat to the person and I may just had told the person in confidence, or I leave a note on someone's window when it falls off? It's the intentional conveyance of a threat, not to go on and do the harm.
Right, and I think that's why the wording is expression of an intention to inflict harm rather than an intention to actually follow through on the threatened harm. I think it's pretty clear that's not what's required even under counterman. It is the harm that follows from someone being threatened. So whether you intend to follow through on the harm or not, is that responsive?
No, I think you're out with intent to convey. That's what I'm.
Yeah. So, and
Which leads you to element number 4, right? Because you say that element number 2 and element number 4 get you over to the promised land.
right.
And I'm saying I don't buy 2. What's your argument on 4?
Sorry, the order of the.
4 is that the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear that the defendant had both the intention and the ability to carry out the threat.
Yes, and I apologize. So I think, well, that largely goes to those situations, as in Watts, for instance, where it's, the speech has an expressive value, but no reasonable person would take it as a threat. It's political hyperbole, maybe it's a joke, but nonetheless, again.
But that's about what the receiver hears and whether that's reasonable. That has nothing to do with the mens rea of the defendant.
Right, so I think.
Okay, so what of these jury instructions has something to do with the mens rea of the defendant?
I think, again, it's both, because they have to be read in conjunction, not separately, but the intention to communicate, the intention to inflict harm. I think that double intent adds up to the specific intent, and I would refer to earlier decisions of this court, Chow in particular. I think it's at 236, where the court articulates its understanding of truth threats as distinguishing between words which might literally threaten and words which are intended to do so. So I think it's Shawley where a direct and explicit threat of violence delivered directly to the target of that threat, there's typically very little ambiguity or doubt about threat. But where it's communicated via a third person, this court has interpreted as requiring.
The Supreme Court's not caught up with the second or third person issue. It's saying there needs to be subjective understanding of the risk, right? And we don't have that because, as Justice Wendland points out, the fourth one is what a reasonable, receiver So a reasonable person would feel threatened, but we have to decide whether, after Countryman, that it's reckless, right? We got no way around this, don't we? I mean, isn't this fold up the tent and add the instruction and move on?
I think certainly if the court wanted to, tweak the instructions.
Consistent with the First Amendment.
Right.
Right, if we were going to do that,
Yes, but
let's just say, we'd have to amend the instruction. So this conviction, let's just say, gets vacated because, let's assume for the purposes of argument that it is inconsistent with Counterman. Can you address the other argument about the facial challenge to the statute and the chilling effect of having that statute in those words without the mens rea, whether or not we can fix that?
Yes, so I think our threats statute, which, kind of does not define what the elements are, those have been supplied by the court in line with the Supreme Court's First Amendment jurisprudence on what qualifies as a true threat. That statute has not have to have been amended following numerous First Amendment decisions. I don't think this one is any different. The court, within its power, can read in the necessary mens rea to save it if necessary. Again, our position is that intent.
Is that because we're educating the people who will enforce the statute? Don't go after them unless you can prove this. Is that, because the general public is not going to know that we've added a fifth element to our instruction. But I take it that's not the standard for overbreadth and.
Right.
Right. Mm-hmm.
Correct. But again, as to that, and I just want to make the point again, where in Chow, again, this court, in its interpretation of the threats, has been attentive, again, to that distinction, words that might on their face threaten, but as opposed to those which are intended to threaten. But Walters is a case which looks at both federal and Massachusetts precedent, and at page 425 there, they acknowledge that the true threat doctrine applies to, again, direct threats of violence delivered directly to that person, but also to words or actions that place the victim in fear and evince an intent on the part of the speaker to put the person in fear. And similarly, in Kearns, at page 653, the threat element is interpreted to mean that communication be made to the person or intended to reach that person indirectly. But if it's indirect, the threats require the intent to put the victim in fear. So again, I think that goes under Shawley, where it's a direct, explicit threat of violence directly to that person. There's little doubt about the intent. And then once it becomes an indirect or not a explicit threat, then there needs to be the additional showing of, indirect threats require an intent to put the victim in fear. Again, that's at 653 in Kearns. So under, again, sort of those principles taken together, I think our statute, as Justice Sotomayor in her concurrence noted, reflect a common sense understanding that threatening someone is an intentional act. I think that's what this court has done with Section 2 historically, so I don't think Counterman affects that. If there are no additional questions, I would